environment is an essential part of human existence. We exist in a natural environment which provides us with all the nourishment, breathing space and all other amenities. This environment has come under a lot of stress because of vastly increasing human population, because of human activities such as mining, industrial production and burning of large amounts of fossil fuels. These are just a few problems which human activities pose to the continued well-being of environment for sustaining life. Of all the social welfare measures, probably the highest are those that deal with sustainable development, that deal with utilization of resources in a manner which can be continued from generation to generation. The environmental problems of a country are determined by the stage of technological and social development, the nature of the economy and the larger prevailing environmental framework. The socio-economic backwardness of a country presents unique problems for a country with a large population. In the course of this unit, the prevailing legal framework for environmental management will be analyzed, including a detailed assessment of related legislations, laws, regulations, environment tribunals and important judicial developments. The human capability of dealing with or altering environment were extremely limited. To utilize more land for cultivation of food grains which could be utilized by human beings required a lot of effort. To put it simply, the ability of nature to regenerate itself was far stronger than the ability of human beings to damage it. Therefore, there was never a problem of trying to save the environment. However, with the passage of time and especially after the heavy mechanization and the advent of industrial revolution, the sides were changed. It became possible for human beings to deplete environment at a level which could render it impossible for the nature to replete. Let me give you one more example. In earlier times, the Britishers gave awards for those who killed tigers. You all know that currently there are widespread campaigns to conserve the tiger, to save the tiger. Then how could anyone award others for killing tigers? The reason was simple. At that time there were too many tigers and they were a nuisance to the people living in those areas. It was not possible for the locals to deal with those tigers. However, today the situation is entirely altered. We have spread to an extent that it is impossible for animals and plant species to continue to grow because of unabated human expansion. This expansion has grown out from the area of need to the area of greed, and that is where the problem starts. Let us now look at the advent and development of environmental activism. With the growth of awareness levels of the general public in the developed world, new laws, regulations and government agencies were created at the international, regional, federal, state and local levels. Many countries, including India, sought to protect the environment through legislative means. Regulatory and legislative instruments have been created to ensure complete adherence to rules outlined for the protection of the environment. To emphasize on the importance on the principles of environmental management, many important principles such as prevention of environmental pollution, right to clean water, protection of the environment, restriction on use of natural resources and sustainable development have been incorporated in the constitutions of various countries. Post the United Nations Conference on Human Environment in Stockholm, the Constitution of India was amended to include protection of environment. The 42nd Amendment Act 1976 of the Constitution of India has included a fundamental duty in Article 15A, Clause G, which states, "It shall be the duty of every citizen of India to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and have compassion for living creatures." Article 48A has included as a directive principle of state policy that the state shall endeavour to protect and improve the environment and safeguard the forests and wildlife of the country. We therefore see that at the very core of our environmental jurisprudence lie these constitutional provisions. It is very important to give the environmental issues a central and important place in constitutional jurisprudence. The reason is, unless they have a sanctity to them, it might be difficult for them to be implemented. Environmental issues almost always conflict with developmental issues. Unless they have a greater sanctity than mere verbosity, they will not be implemented properly. We will now look at the environmental and legal framework of India. While traversing the history of development of environmental statutes, it is interesting to note the development from early resource exploitation legislations to resource management legislations to more recent legislations which are framed from the perspective of the protection of the environment and ensuring sustainable development. While framing effective legislations for environmental management, it is necessary to ensure that the participation of all concerned interest groups and incorporation of their interests within the legislative framework is taken into account. The next important consideration in respect of developing states is sustainable development, which is focused towards achieving a balance between the environment and development. Finally, as stated in the Rio Declaration on Environment and Development, while framing the legislations, the character of specific states should be taken into consideration. The legislative framework for environmental legislations is extensive and it includes provisions in the Penal Code, legislations to preserve the environment and natural resource laws, anti-pollution legislations, and statutes which pertain to specific matters such as protection of forests, land use, and wildlife habitat. In the course of this section, it would be relevant to examine some important environmental legislations in India. The first and probably the more important of these legislations is the Environmental Protection Act 1986 and the Environment Protection Rules of 1986. This act provides an overarching framework for the protection and improvement of the environment. It permits the central government to improve the environmental quality, reduce pollution, as well as ensure a reduction or restriction on the operation of industrial facilities if they breach environmental norms. It outlines the responsibilities for obtaining environmental clearances for new projects and lays down other procedures relating to setting emission standards. Therefore, you can see that the Environment Protection Act is a very broad-ranging statute. It seeks to ensure that industries and other producing entities do not grow or form in a manner which destroys the environment and thereby hampers all welfare attempts. The second legislation in this series of environmental legislations is the India Forest Act 1927. As you can see, this is a pre-independence act. It consolidates the laws pertaining to forest and forest produce and transit of timber. It has also been empowered to prevent the poisoning of water in forest regions through enforcement of rules. You need to understand that the Forest Act is a colonial legislation. Its primary objective was not necessarily the welfare of people. While it might still have certain important elements which help us conserve the environment, the primary focus of the Forest Act was to make sure that the Britishers continuously can exploit India's forest resources. We now go to the third legislation, which is the Forest Conservation Act. This act incorporates measures for protection of forests and regulations of the forest lands for the non-forestry purposes. In certain cases, as specified in the Act, it is mandatory to obtain the prior clearance for concerned authorities. As you can see, this Act deals more not with the utilization of forest resources, but it deals with what should be done to make sure that the utilization does not destroy the forests. As you can see, it is also a post-independence legislation, and therefore it focuses more on welfare and less on benefit. The next legislation which we are looking at is the Hazardous Waste Management and Handling Rules of 1989. These rules, the Hazardous Waste Management and Handling Rules, deal with the manufacture, use, export, import and storage of hazardous microorganisms. These rules were primarily formulated in the aftermath of two incidents, one of which was the Bhopal gas tragedy and the second was the oleum leak case, which is also known as the MC Mehta case. These rules tried to make sure that the hazardous waste or the hazardous products used in any industry or used in any production facility do not harm the people around them. Secondly, the rules dealing with hazardous microorganisms or cells also deal with such microorganisms or cells which can introduce severe problems in environmental management and may cause harm to livestock, human beings or other living entities. The fifth set of rules are the Biomedical Waste Management and Handling Rules of 1998. These rules seek to ensure that hospitals and healthcare institutions undertake the proper handling and treatment of biomedical waste. The sixth in the series of these legislations and rules is the National Environment Appellate Authority Act 1997. This act provides for an appeal mechanism in those cases where the environmental clearances are required in certain restricted areas. This appellate authority was set up to expedite the process of obtaining environmental clearances and to make sure that unnecessary delays were not introduced in the same. The seventh is the Wildlife Protection Act of 1972. This is an extremely important legislation, as this was the first comprehensive legislation relating to wildlife passed by the government. It makes a provision for the protection of animals and birds and matters concerned with their habitat or forest. The eighth act is the Air Act, which in its full expanded form reads as the Air Prevention and Control of Pollution Act. The primary object of this act is to prevent, control and abate the air pollution. Powers for enforcement of this act have been vested with the Central Pollution Control Board. The ninth act is the Factories Act. This legislation identified the concerns related to the work environment of the workers. Through the 1987 amendment, the application of this act has been extended to hazardous processes as well. Then there is the Water Act, which in its extended form reads as the Water Prevention and Control of Pollution Act. The primary focus of this legislation is on creating a structure for prevention or reduction of water pollution. The Act aims at the establishment of central and state pollution control boards to enable the members to carry out the purposes of this Act. The polluting industries are mandated to seek the permission before the discharge of their waste. The next Act is the Indian Fisheries Act. Indian Fisheries Act is a pre-independence act, and it deals with the manner in which fishing can be conducted in India. The last notification which we are dealing with is the Coastal Regulation Zone notification. The Agenda 21, which was adopted in Rio de Janeiro, was a significant landmark in development of international environmental law, as for the first time it outlined some relevant concepts of management of the environment. While there is no binding instrument of international character, important principles such as polluter pays principle, principle of non-discrimination, precautionary principle, and principle of intergenerational equity should be highlighted. It is relevant to list down a few important legislations which constitute the larger international framework of environmental law. First, for atmospheric pollution, the 1979 ECE Convention on Long-Range Transboundary Air Pollution Protocols on sulfur dioxide, nitrogen oxides, and volatile organic compounds. The second is the 1985 Vienna Convention for the Protection of the Ozone Layer, Montreal Protocol, and London and Copenhagen Amendments. Then there is the 1992 UN Convention on Climate Change, which has the Kyoto Protocol ratified in 2005. Moving on to marine pollution. In 1973, the Convention for the Prevention of Pollution from Ships was passed. In 1982, UN Convention on the Law of the Sea was accepted. In 1992, the Paris Convention for the Protection of the Marine Environment of the Northeast Atlantic was adopted. In 1952, the Geneva Conventions on the Territorial Sea and Contiguous Zone, the High Seas, Fishing and Conservation of the Living Resources of the High Seas and the Continental Shelf was adopted. Hazardous waste. In 1989, the Basel Convention on the Control of Transboundary Movement of Hazardous Wastes and their Disposal was adopted. In 1991, the Bamako Convention on the ban of the import into Africa and the control of transboundary movement and management of hazardous wastes within Africa was adopted. Regarding nuclear energy, in 1986, the International Atomic Energy Association Convention on Early Notification of a Nuclear Accident was adopted. Also in 1986, the IAEA Convention on Assistance in the Case of a Nuclear Accident was adopted. In 1994, the IAEA Convention on Nuclear Safety was adopted. Let us now make a brief analysis of environmental law. Environmental law should be distinguished from other types of laws insofar as it is not restrictive in its scope. It impacts not only personal interests, but the interests of the public at large, and it includes within its ambit a range of social activities. Environmental law can be classified as convention environmental laws, national laws, as well as international laws. The convention-based law is founded upon the prevailing practices and conventional behavior in respect of environmental problems. National laws are enacted to improve the existing environmental conditions, pollution control, as well as eradication. International law promotes close cooperation amongst states for ensuring the protection of the environment. Environment tribunals. Institutional mechanisms are necessary for the proper enforcement and implementation of the laws as well as regulations. Post 1970, when the judiciary became responsive to arising environmental concerns, it was envisaged that environment tribunals could be established. The National Environment Tribunals have been set up under the National Environment Tribunal legislation. These provide for a stringent liability in cases of damages suffered due to an accident, with the object of providing adequate relief and compensation to affected persons. Understanding the role of green benches and public interest litigation is the next topic which we are going to look at. Benches which are constituted by the Chief Justices of High Courts or by the Chief Justice of Supreme Courts are defined as green benches and they deal exclusively with environmental related issues. Due to the absence of effective environment tribunals, the green benches have been established and they have been instrumental in issuing many judgments and orders to promote environmental conservation. States which have constituted green benches include West Bengal and Tamil Nadu. While adopting the course of public interest litigation is popular in cases of violation of human rights and fundamental rights, in recent times, right to health and a clean environment is also sought to be enforced through this method. Important issues which have been addressed by the Supreme Court of India include disposal of hazardous waste, manufacture and sale of pesticide, depletion of groundwater and closure of the pollution factories. In fact, in the Taj Mahal case, international concern was expressed over the noticeable deterioration of the Taj Mahal. Renowned environmental lawyer M.C. Mehta filed a writ with the Supreme Court to ensure that orders for the restraint or removal of pollution causing factories be issued. Based on a survey report submitted by UPPCB, the Supreme Court, which is the Uttar Pradesh Pollution Control Board, the Supreme Court ordered the service of notice to industries to ensure that they adopted anti-pollution measures. For those who failed to, the factories were required to be shut down in accordance with the order of the court. Let us finally look at the drawbacks in the implementation of environmental legislative measures. It is important to highlight the concerns relating to ensuring the effective implementation of legislative measures. These include the following. First, in most cases, the environmental legislations have only incorporated punitive sanctions without outlining measures for preventing the commission of environmental offences. The concerned authorities take action after the damage has been caused, and the same does not serve the purpose of protection and management of the environment. The statutes of environmental legislations do not specify guidelines on the role of the authority and scope of their rights and obligations. In their absence of a formal structure and functional guidelines, the statutory authorities can be rendered ineffective. Next, although the legislative mechanisms have been laid down, as in the case of the National Environmental Tribunal Act 1995, it is seen that the lax attitude of the administration affects its proper implementations. Also, since the powers of the authorities are not properly defined, their exercise of powers and functions may overlap. The primary concern with environmental legislations is that they do not involve the participation of people for purpose of their implementation. This needs to be immediately addressed. There is also an issue of inadequacy of budgets. Further, the cooperation of the public is critical for the successful implementation of environmental legislations. For instance, in a recent case where the Supreme Court made it mandatory for the public transport vehicles to use CNG for purpose of transport, it led to a disappearance of public transport vehicles and was followed by a huge public protest. While the development of case laws and enactment of new legislations has contributed to the evolution of environmental jurisprudence, it should be stated that the effectiveness of the proper implementation of these legislations is yet to be achieved. There is a need to increase the participation of people in environmental processes on one hand, and on the other hand to strengthen the administrative machinery to ensure the successful enforcement of these legislations.